The day is finally here. You are ready for your pretrial deposition in your medical malpractice case. And now you've replayed in your mind over and over and over again the different types of questions you will be asked and the answers that you expect to give. What happens though if you don't remember every single detail of every single event, of every single question that's asked of you? Would you like to know the answer? Do you think it's going to destroy your entire case? Come join me as I share with you the answers to that question and those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney, as I'm navigating going down these rocks near the water here. All right, so now you brought a medical malpractice lawsuit against various doctors claiming that they were careless and caused you significant harm and injury. And now, as part of your lawsuit process, you will be required to answer questions by the attorneys who represent the various people whom you have sued. This is called a deposition, a pretrial question and answer session given under oath. And although it's somewhat informal because this is done either on a Zoom video call or in your attorney's conference room, you may think, hey, it's not a big deal if I don't know the answers. It's not a big deal because we're not in front of a judge or in front of a jury. We're not in court. Let me get that thinking out of your mind. Even though this is done in a somewhat informal setting, every single answer you give represents your sworn testimony, and it carries the same exact weight as if you are testifying in court at trial in front of a judge and in front of a jury. So now, let's get back to the question that I raised, which is, you have been replaying in your mind over and over again all the details from the incident that occurred here. And now, this incident occurred more than 2 years ago. But because you've been replaying it over and over again, you have a distinct memory of all the minute details that occurred. And you are prepared to tell the defense attorneys every single detail, every single minute detail of what occurred. Now, there comes a point where you are now asked a question to which you simply don't know the answer. And now you're getting frustrated because you don't recall the answer. You want to go ahead and guess. You want to go ahead and give an estimate. But your attorney has told you not to guess and not to give an estimate if you're unsure. But you are worried. You are very much worried. You are afraid, in fact, that if you give an answer that is not precise, that is not exact, that is not definitive, you think it's going to destroy your entire case. You think the defense attorneys will think much less of you and think that you are not the perfect witness. They will now use that, you think, to go ahead and minimize the value of your case. You will use that deficiency to think that your case is now over, that the value of your case has been diminished, and now they're going to report, the defense attorneys are going to report back to their people, to their principals, that you cannot be trusted. Why? Because you simply don't remember the exact moment in time in which something occurred. Is that all true? The answer is absolutely not. The perception that you may have thinking that because you don't know all the exact details and all the minute details of every single instance, every single event that transpired in the hospital or in the doctor's office, you think it's going to destroy your credibility. I'll share something with you, just the opposite. There is nobody that I know of, and I'm doing this now more than 36 years. I don't know of a single injured patient who can go ahead and recollect and remember every single minute detail of every single interaction that they've had. Impossible. And especially after a year or two after the incident occurred, there is no possible way you could ever be expected to know all the specific details. And I'll give you an example. Let's say you had 10 visits with your doctor in the office. Now the defense attorney is asking you detailed probing questions about every single thing that happened in the office. What did you complain of? What did the doctor do? What was done for you? What physical examination did the doctor do? What interactions did you have with the doctor's assistant, with the doctor's nurse? What did they say? And now they're asking you detail by detail of every step of every visit that you encountered with this particular doctor. If you were to remember every single minute detail, that would be remarkable. If you were to remember the answers to every single question that they asked, I certainly would be suspect. I would question you as to how it's possible you remember every single detail of every single interaction that happened more than 2 years ago. In my opinion, it's simply not credible to remember all those details. In fact, it's the norm that people simply don't remember all the minute details. You're going to remember some of them, and you're going to perceive that you recall the answer to a lot of them, but don't think for a second that if you don't remember every single detail of every single event, that it's now going to destroy your credibility, because the reality is that that's not what occurs. That's not what happens. Your credibility will not be shot because you are being honest and forthright and simply say, look, I just don't remember. I remember many of the details, but not all of them. In that instance, it's perfectly okay to say, I'm sorry, but I just don't remember. It's totally understandable that you want to go ahead and give the best impression you can, and you think that by knowing all the answers to the defense attorney's questions, that will make you a better witness, it will make you a better plaintiff, and now you come across as being a more credible witness. The answer is no. If you don't remember all the details, in my opinion, that makes you a better witness. Because if you did remember everything, you'd sound almost like a robot, like you had practiced and rehearsed all of your answers, and now you're giving canned answers to questions that you think is going to help you during the course of your lawsuit, when in fact, I believe that it's just the opposite. So why do I share this quick information with you? I share it with you to disavow yourself of the notion that you must be perfect and must know the answers to every question you are asked in order to get the defense attorneys to recognize that you are a formidable witness. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.